So we've jumped forward again a little bit in time. We've gone all the way up to 1968. So what are the facts in Duncan v. Louisiana? Well, the defendant in this case was charged with a misdemeanor, simple battery. So one of the most basic physical charges you can have, a simple battery. The trial judge in the case in Louisiana denied the defendant's request for a jury trial because Louisiana state law provided for jury trials only in capital or other grave cases. Now, that should obviously fly in the face of the Sixth Amendment, which guarantees a jury trial in cases, in very similar cases in federal courts. There is a background going on here. Race was absolutely an issue in this case. Absolutely. Jury trials were more likely to be denied to African Americans in Louisiana than whites. And that is exactly the issue that's happening in this case. But the main issue, and the issue that we're going to focus on, is the right to a jury trial fundamental? And if so, should it be selectively incorporated through the Due Process Clause of the 14th Amendment? And the answer to that, finally in 1968, is yes. And the court says, because we believe that trial by jury in criminal cases is fundamental to the American scheme of justice, we hold that the 14th Amendment guarantees a right of jury trial in all criminal cases, which, were they to be tried in a federal court, would come within the Sixth Amendment's guarantee. So the question here for the court hinges on this idea of a fundamental right. So you've heard this language brought up in Adamson, and this language comes back up in Duncan. And so it hinges on this idea of fundamentalism. And the court holds that, yes, this is a fundamental right. And the court goes to some extensive explanations about why the jury trial is fundamental. The argument in this regard is that the jury trial was foundationally important to the United States at the time of secession, or at the time of its breakaway from England. It is a cornerstone of the justice system, so much so that the founders absolutely included it in the Bill of Rights because it was seen as a protection against the atrocities that occurred under the British Crown. And therefore, you can't envision our American scheme of justice without criminal trials being held before a jury. And so, therefore, it's a fundamental right. It is part of what makes American society and American government distinctly different, distinctly American. That's what we sort of hinge on, this idea of fundamental. And so in this case, the court says, well, absolutely, we will apply the Sixth Amendment protection to jury trial in criminal cases to the states. This is the process of what selective incorporation looks like. This doesn't mean that a plethora of other portions of the Bill of Rights were made applicable to the states. Just this one tiny example. We're to the point now, however, where this incorporation seems almost complete, almost in totality, that a majority of the Supreme Court ever since 1968 has agreed that incorporation is a thing. And so while they never signed on to Justice Black in totality, believing in total incorporation, the move forward for the court is that the Bill of Rights have to be seen as applicable on the states through the 14th Amendment. Now, the 14th Amendment here serves as the workhorse for the rest of this course, because it is the method by which the United States Supreme Court gets its hands down to state action. So when states do something that run afoul of the Bill of Rights, it's the 14th Amendment allows states to reach in and change it. But the 14th Amendment is also dangerous. And this is a warning that we'll revisit going forward in the future. Because of this language of fundamental rights that has become key to the court's jurisprudence in this area, we need to understand that there is another side to using that particularized language. The court is in agreement almost universally through this time that there exist fundamental rights that are not included in the Bill of Rights, that there exist rights that are so fundamental to be human that the Bill of Rights protects them. In fact, the Ninth Amendment seems pretty clear on that. But because of the way the court has carved out this area of jurisprudence, that there are certain fundamental rights, and fundamental rights by their very nature are applicable to the states through the 14th Amendment. If the court were to find a fundamental right, it would then become national law. And the court has done this not an insignificant amount of times. Perhaps the most notorious is when they found somewhere within the Constitution the right of contract, which was at that time considered a fundamental right for an individual to be able to contract with another individual for the basis of labor. Well, because of that perceived fundamental right, this fundamental right of contract, things like minimum wage laws, maximum hours worked laws, safety protections, all of them were struck down as unconstitutional, despite the Constitution and the Bill of Rights being absolutely silent on all of those issues. And they were struck down as being unconstitutional because the Supreme Court thought that right of contract was fundamental. Now, there are two ways to change something when the Supreme Court says it's a fundamental right. One, amend the Constitution. I'm here to tell you that's not happening, and that probably in your lifetimes will never happen. Just because the mechanism itself requires such supermajorities at every step along the way, and as divided as our country is, I just absolutely do not see it happening. So you can amend the Constitution. Probably not going to happen. The other way that you can change the finding of a fundamental right is to change the Supreme Court itself. Well, unless you want to attack the Supreme Court head on and pack the court, which we've seen to be divisive, you simply have to wait for replacement. Or, and this is the third option, which actually has occurred in our history, hope that the Supreme Court changes its mind. That happened for the right of contract. The right of contract was a fundamental right, and then after FDR attacked the Supreme Court, it ended up not being a fundamental right because two justices on the Supreme Court changed how they were voting, and basically the right of contract fell away as a fundamental right. But we live in a society right now that has at least a couple fundamental rights that aren't at all in the Constitution. Marriage is a fundamental right, but it's not in the Constitution. It's nowhere there. And so even going back as far, and we'll cover it in this class, Loving v. Virginia, where Virginia had a law against miscegenation, which is individuals of different races becoming married. The Supreme Court said that marriage is a fundamental right, and therefore states cannot restrict marriage based on racial identity. I have no problem with that decision. I think it's great. It's also the binding precedent for the Supreme Court's decision just a few years ago regarding gay marriage. It's like marriage is a fundamental right. That includes gay marriage. Now, gay marriage is a fundamental right. I still personally think that's an excellent decision policy-wise. I think it's a really dangerous decision in the method by which it got made. Because there's nothing saying that a majority of the Supreme Court, again, can't read something as fundamental into the Bill of Rights and therefore make it applicable upon the states that I would disagree with. So I'm a critic of this process of incorporating rights into the Constitution that are not textually there because I fear for a future where I'm not going to agree with the rights that get read into the Constitution. So just a warning that going forward, this process of incorporation could be problematic because we can continue to incorporate. And if the Supreme Court finds something as fundamental that, I don't know, the majority of society disagrees with, there's really nothing that society itself can do without attacking the institution of the court, without amending the Constitution, which, asterisk, not going to happen. All we'll have to do is wait and hope that the Supreme Court changes its mind. That's a dangerous place to be when it comes to the protections and also restrictions that the Bill of Rights can put upon us. Questions? Can you give an example of a fundamental right that might be fundamental but is dangerous? Well, the first one, the right of contract, that's dangerous. And it was dangerous. So we couldn't have things like minimum wage laws. We couldn't have things like child labor laws. Because if it's a fundamental right, well, then an individual at the age of 6 years old can absolutely contract their labor away in that sort of essence. And that's dangerous and probably not a good operation of what the court could do. These fundamental rights can be taken away by SCOTUS, like overturning Roe v. Wade. Exactly. So that's a good example I didn't use. So Roe v. Wade incorporates a fundamental right to an abortion into the Bill of Rights based upon privacy rights. A court can absolutely overturn that and make it not a fundamental right. Yeah, absolutely. It just so happens that most of the things that we're listing outside of the liberty of contract which was considered conservative activism. The rest are things that liberals tend to agree with, and so there's been less of critique about them from liberal academics about the process. And so another student says, so fundamental rights are held to the Supreme Court's discretion. Without constitutional guidance, yes, fundamental rights are at the discretion of the United States Supreme Court. And you can see that. So where's privacy in the Constitution? The answer is nowhere, but it's a fundamental right now, that individuals have a fundamental right to privacy. And included in that is sexual privacy, which included in sexual privacy is the right to an abortion. So the way that this goes is there exists a right to privacy. There exists a sexual right to privacy. And the way that that gets brought up is there were certain states that had laws against birth control. And the Supreme Court says, no, what happens within a family's bedroom or any individual's bedroom is not the concern of the state. And therefore, birth control laws, violation of the right to privacy. Well, the next step for that was abortion is a violation of the right to privacy. So you might agree with the beginning of the fundamental right, privacy itself. You may not agree with where it ultimately gets, abortion. But they're all fundamental, and the only way for any of them to change is by the Supreme Court or by amending the Constitution. And so it's an extreme power that the Supreme Court has in this area. And I would just make the argument that if you are a fan, or not a fan, that's a stupid way to put it. If you are pro-choice, you should be absolutely scared of the way by which the Supreme Court made pro-choice or made abortion legalized nationwide. Because what it means is if the Supreme Court changes to a conservative majority like the one we have now, all they need to do is overturn Roe v. Wade. And then it's left up to the states again. And don't presume that the state of Texas would have legalized abortion going forward. It would pretty much be done. And so this idea of fundamental rights just makes them too, I don't know, impermanent, I would say. Oh, wow, there's lots of questions. Okay, we'll deal with this. I'm scrolling up. I've heard the term super precedent before. How does that tie in? What are some examples? I mean, there are very few examples I would say are super precedents. And super precedents are things that everyone, there are a couple ways to talk about it. The way I think of super precedents is super precedents are something you have to agree with to get on the federal judiciary. That everyone has to say, for example, that Brown v. Board of Education is good law and correctly decided. That's a super precedent. There's no way that you could get a judge confirmed to the federal bench who doesn't sign on to Brown. But that's not true of Roe. You could easily get numerous judges signed onto the bench who disagree with the fundamental decision in Roe. I think there are very few super precedent cases. A lot's made about them, but I don't think there are all that many. And many of these fundamental rights cases are definitely not super precedent in that sense. So next question. If marriage is a fundamental right, doesn't that mean they can't outlaw any type of marriage? No, because like all rights, there are restrictions. So there are restrictions that states can make on marriage rights. So for example, the reference that the student brings up is interfamilial marriage. Well, the reasons why there are prohibitions at the state level on interfamilial marriage are health reasons. And so restrictions for the reasons of health can absolutely be regulated by the state. So fundamental doesn't mean total. It just means that the restrictions have to be made with other considerations. It can't be a yes or no. Fundamental rights are considered the implicit side of the Bill of Rights. Yeah, that's one way to say it. Is that remember what the Ninth Amendment says, is that rights not contained herein are hereby given to the people in the states. Or basically, don't read this document as a complete expounding of the rights that individuals have, that individuals still have other rights outside of this document. Well, the courts have gone to finding certain rights outside of that document and reading them in as fundamental, which is basically slotting them into the Bill of Rights. But they can be changed by a future court who disagrees with the fact that said right could be fundamental. Going off Sarah's question, could all marriage be deemed no longer a fundamental right? Yeah, it could. The court could simply go, federal government shouldn't be dealing with marriage. The marriage is nowhere in the Constitution. The federal government should not make any laws respecting granting of marriage or restricting of marriage. They shouldn't be in the business of marriage to begin with. And marriage is not a fundamental right, and the federal government shouldn't touch it. The court could do that. The court won't do that. The court could do that. Going off the slaughterhouse cases. The slaughterhouse cases, they use privilege immunity clause in their defense against the monopoly. Does that mean that the Supreme Court has the ultimate say on what privileges and immunity we have? Absolutely. Absolutely. Supreme Court has a say on almost all of our rights. They are the arbiter of what the Constitution means. The other two branches have given that up. Remember when I said earlier in the class that the Supreme Court and the federal judiciary tells us what the Constitution and what our laws mean. That's not the power of Congress. Congress has the authority to make law. The president has the authority to enforce law, and the court has the ability to interpret law. At least, and we've only settled on that because that is the little fiefdoms that each of these institutions have carved out. Remember, the Supreme Court doesn't have this power because of the constitutional grant. They have this power because they claimed it. And so, yeah, the Supreme Court absolutely does have the authority to say what privileges, immunities, and also other rights that we have. Whether that's correct or not, or good or not, that remains to be seen. But it's very clearly within their authority So much so that other members of Congress know that in order to, or other members of the government know that in order to change these things, they would have to amend the Constitution. Can SCOTUS deem presidential executive orders unconstitutional? They could, but since they've already declared that some of them are constitutional, they won't. Here's the thing most people don't understand about executive orders. I'm assuming the vast majority of you all are employed. If your boss sets out a rule for your job, that's the rule. When the president issues an executive order, he's commanding executive officers to do a thing. He has the authority to do that. He's their boss. So if he commands, for example, immigration INS agents to not deport anyone for the next 100 days, those are his employees. He can make that order, despite what a judge in southern Texas might say. That TRO will be struck down very quickly. In fact, it's so, by the way, for anyone who's actually following along, it's so badly written and that judge so really doesn't understand how immigration law works that the way in which the TRO is written is probably, in fact, I would go so far as to say, absolutely not enforceable. Because the president already legally has always had the discretion to do this. Yeah, it's just not good.